Good morning. Apparently, we are competing with Kim Kardashian this morning, who is appearing at Chadstone. So thanks for choosing me. Although apparently her ass flies in tomorrow on its own privately rented jet. And if those who didn't know that Kim Kardashian is in Melbourne, if you want to leave now and go to Chadstone, be my guest. In any event, let's get on to the more topical things. Valuing interests. So the courts provide for valuation of the interests, the shares in the corporation, as fair value, as opposed to other concepts of market value or fair market value. There are some nuances there with fair market value. That's provided for in the Scottish Co-op Wholesale Society decision of Lord Denning. It's probably best to look at what fair value is by contrasting it with other concepts of market value. And the market value concept clearly comes from what we understand the position from Spencer and the Commonwealth. That's in relation to land in particular, and then Justice Williams in Abrams and FCT. And effectively, market value is the price that would be negotiated in an open and unrestricted market between a knowledgeable, willing and not anxious buyer and a knowledgeable, willing but not anxious seller acting at arm's length. That's market value. Then you've got the concept or the overlay there of fair market value, which contains the notion of removing vagaries and idiosyncrasies or special circumstances that might exist to distort market prices. So, for example, whether the shares or goods, whatever it is thinly traded in the market, whatever other market conditions might apply. And then, of course, when you're looking at fair value, you're looking at a lot of other subjective factors that might effectively distort or change the price of the shares. There's a very helpful authority, and that's MMAL Rentals and Bruning. It's not an oppression case, but it talks about the distinction between market value, fair market value and fair value. His Honour Chief Justice Spiegelman said this: whereas here the formulation is fair market value, the valuation test requires a similarly limited focus on the range of circumstances relevant to a process of determining exchange value. A, quote, fair market value may diverge from market value for numerous reasons. For example, where a property is thinly traded or the parcel is small, or there exists market distortions. In the present contractual context, the intrusion of the word market between fair and value points away from a process of determining what is just or equitable between the parties, which is more the oppression context, from a process in determining towards an objective standard. That is, so in the present case, is strongly suggested by the decision maker nominated in clause 11.23. The decision is to be made jointly by the company's auditor and a chartered accountant, nominated by the vendor and failing agreement by a nominee of the president of the Institute of Chartered Accountants. Persons with such a background are not generally suited to determining what is just or equitable in all circumstances. Their expertise is appropriate for determining exchange value. Nevertheless, the word fair has, in my opinion, work to do. In a contractual context, this additional word suggests that the valuation should proceed on the assumption, which may be contrary to the facts of a particular contractual relationship, that there is no impediment to the process of bargaining, whether in terms of availability or information or restraints arising from the characteristics of a particular vendor or purchaser or otherwise. Issues will arise, however, when determining what aspects of the particular relationship are of a character which inhere in the item of property itself as distinct from those which should be treated as excluded by the concept of a fair market value. So you've got those three concepts: market value, fair market value and fair value. And that decision is helpful in illustrating how the court looks at the varying different concepts. In terms of an oppression action, valuation's got to be fair on the facts of the particular case. Fair value has to take into account what the price of the shares would have been worth if not for the oppression, and the court takes into account the negative effect of the oppression on valuing, which is often hard to do and is often quite a subjective process, as we will see. The different methodologies will take into account whether or not the business is continuing as a going concern, or whether or not it's proposed that the business is to be liquidated. And there are a range of different valuation methodologies that have been applied by the courts. The process itself is often described as a combination of the accounting process per se, or the accounting exercise, and then judicial discretion overlaid. And that's been described quite aptly by His Honour Justice Young in the Mike Gaffigan Marine case, and I'll give you the citation in the notes, where His Honour said, quote, "I realise that the value which I have reached is greater than that reached by either valuer. I am not fazed by this. My job is to find as a question of fact what the value of the shares is, and I treat the accountant's evidence as merely being material to assist the court." And His Honour in that case took into account a number of different characteristics, and he determined or considered in a proprietary company context the following matters that impacted upon valuation. A reasonable purchaser would be influenced by restrictive provisions in the company's constitution, and therefore there should be some discount. Directors have fiduciary duties which can be policed. Litigation to enforce compliance with directors' obligation will be expensive, all factors to take into account, but it will be also expensive for directors, so compromise somewhere along the line is likely. Each case must be looked at in its own circumstances. A large discount merely because of the presence of restrictive clauses would not necessarily be appropriate. And in relation to minority holdings, His Honour listed the following factors, those preceding remarks. Then if the holding is of a size less than that required to block a special resolution, the holder is at the mercy of the majority, but the courts are still able to contain the wrongdoing of the majority. To a great extent, directors will be able to make determinations as to retention of money, dividend policy and the direction of the company. But there is an area outside the line where the courts will exercise control, and where the valuation is on an asset backing basis, the smaller the value of the shares without discount, the greater is the discount that should be applied to the cost and risk of litigation. Now, as indicated there, a number of different methods have been applied. Net asset method has been applied on occasions. All assets are considered, and often there is an adjustment made for nuances with goodwill. Capitalisation of future maintainable earnings. I did a case with a hairdressing business a while ago, and that was the methodology for determination that was applied, with a multiplier in terms of the future earnings going forth relative to that industry. Judge's discretion, and I've given the authority there of request exploration. In that case, the judge made his own assessment, taking into account what a prudent purchaser who knew about the financial risks that the company faced would do and would discount in terms of the value of the shares. And then fair market value, which I've talked about earlier on, was applied in the Shirman-Fesner case. I refer you back to the comments of Chief Justice Spiegelman in MMAL. And then, of course, sometimes if the business is not going to be ongoing, liquidation value will be applied. The problem with liquidation values, of course, is that that might be artificially low in the circumstances. And also, you've got to take into account in the liquidation process all of the other expenses that might occur in that process. That will factor into the value of the shares, including accounting expenses, liquidation expenses, tax liabilities will be taken into account in the valuation of the assets and then the underlying shares. Other factors that are relevant is timing, and the courts have a range of different views and apply a range of different views about when the date of valuation should occur and what should be applied, whether or not it's the date of the valuation in the particular circumstances, whether or not the valuation should be applied as at the date of the oppression or as at the date of the commencement of the proceedings. There are a myriad of authorities where differing timing factors have been taken into account by the courts. And so there are the number of different approaches, and there is a very wide discretion as long as it's fair in the circumstances. In practice, it almost always requires expert valuation evidence. The experience that I've had recently is that the courts actually like to have one valuer appointed, and that's the court appointed valuer, with the parties having a possibility of providing information, equal rights to accessing the information. So the minority shareholder in the dispute will have a very broad ability to access the information that usually the majority shareholder is providing to the valuer. Next issue is the issue of corporate trustees. I'll deal with that very, very quickly. There has been some debate before and confusion about whether or not the remedy, the oppression remedy, was available for trustee companies. In New South Wales, the line of authority generally provides that it has not been available, and Quizkari was the authority or the case there. Again, Justice Young, oppression remedy wasn't available because of the effectively distinction between the business being operated by the trust or being owned by the trust, and the value therefore lying in the business as opposed to the trustee company, which effectively was just a $1 company. Now, in Victoria, that position has changed. It's different. There are a couple of authorities in particular, Vigliaroni, which is a decision of Her Honour Justice Davies, as she was in the Supreme Court at the time, and then that's been followed in Wayne and Drapac, which is a decision of Justice Ferguson, as she was at the time, now an appeal judge. And effectively, in Vigliaroni, Justice Davies said, I conclude I should depart from the view expressed by Young in Quizkari about the equitable interests in the trust cannot be dealt with by an order under Section 233. The only limitation imposed on the court on the kind of order that can be made under Section 233 is a requirement for the order to be one that the court considers is appropriate, quote, in relation to the company. I think Chris talked about Section 53 and the breadth of Section 53, so a very broad reading of that section. The phrasing in the relation to requires a rational and discernible link between the remedy and the company in which the oppression has occurred. In other words, any remedy granted under Section 233 must not be extraneous to achieving the object of relieving the oppression and must be appropriate to putting an end to the causes of oppression, including where the company acts as trustee and the oppression relates to the affairs of the trust. In appropriate cases, the remedy may include orders dealing with the equitable interests in the trust, in my view. And that's been followed in Wayne and Drapac, which again was a relationship where there was an inextricable link between the corporate entity and the units in the unit trust. And I respectfully suggest that in Victoria that would also be followed when you have complex, because these are closely held companies, they're not often not that complex, but partnership overlays with corporations as well. So you often have these situations where you get the companies that operate in this bizarre trust, quasi-partnership situation, and there are queries about whether or not oppression remedies would apply in those circumstances, and in my view, they will, following the Victorian line of authority. If you were bringing the same types of claims in New South Wales, you might have pause to think about that, because it seems that the New South Wales line of authority is still operating, and there has been some criticism of the Victorian line of authority by some of the judges in New South Wales. The last issue that I want to deal with is really the practicality of these remedies, because on the face of Section 233, it provides for a very, very broad range of non-exhaustive orders, and one might read it widely, particularly when you've got orders that allow for a restraint of a person from engaging in conduct or requiring to do a specified act. It suggests that the potential for the court to order anything necessary to bring the oppressive conduct to an end is present in the face of the law. But in my experience, the practice is it doesn't work like that. And the courts usually confine themselves to quite a formulaic, routine, and rarely novel type of remedy, even though the provisions might seemingly lend itself to that. So what the court normally does is this: it will look to crafting an order that removes or avoids the causes of the oppression, and that is referred to generally as putting the company back on the rails. How is it best able to put the company back on the rails? And that usually involves, at first instance, the court determining that the oppression is best cured by the oppressed party being compensated by the oppressor buying out the oppressed party's interests at fair value. And that is the general rule that's usually followed by the court. That is, the majority unit or the majority member buys out the minority member. That's the first port of call. Winding up is almost always a remedy of last resort, and winding up of a profitable and operating company is an extreme measure. The courts will often say that, and usually look to other types of remedies. Now, when we talked about the novelty of the oppression remedies, the appointment of a receiver has sometimes been used as a midway point, or a way to effectively achieve an end, and it often is applied in circumstances where the company itself is profitable, or there's a particular asset within the company that is valuable and needs to be protected or needs to be dealt with in a particular way. And a very good example of that is the case of Macmillan and Toledo Enterprises. It's quite an interesting set of facts, so I'll provide you with a very brief background. The respondent company was incorporated for the purposes of acquiring and exhibiting a Russian submarine in Australia. The plaintiff was one of two directors of the company. Both directors had advanced some substantial loan funds to the company. There was the obvious difficulties and the breakdown in the relationship between the directors, particularly about the budget. And one of the directors claimed that he'd been refused access to the company books and records. That plaintiff, that director, was then admitted to hospital with a suspected cardiac problem, and the other director claimed to have a meeting at his hospital bed whereby he had allowed another person, a third person, to be appointed as a director, the deathbed appointment of another director, and of course the two directors then turn on the director who's in hospital and deal with the company in particular ways by passing resolutions that were quite clearly not within that director's interest. Unfortunately for those other two directors, the director survived his cardiac event, didn't die, and was sufficiently well enough to institute proceedings for the oppression remedy. Perhaps their problem. Now, he denied that he had knowledge of the meeting. I suspect he was hooked up to all sorts of machines at the time and probably under all sorts of medications. Denied he had the meeting, and then he was refused by the other two directors extensions of time for him to act in a particular ways to maintain his interest in the company. Then he brought an application to wind up the company. He realised in the course of bringing the application that the wind-up of the company would destroy the interests in the bringing into Australia of the submarines, the Russian submarines. So there was an opportunity there, business opportunity, that would be effectively destroyed by the liquidator being appointed and the submarine interests being sold off at effectively liquidation values. So the remedy was changed in the course of the running of the proceedings to provide for a receiver to be appointed to effectively take hold of the asset, being the opportunity to exploit the Russian submarines. Not surprisingly, the court did find that there was oppression in those circumstances, did grant the oppression remedy, and did appoint the receiver. A court will order winding up if there is a very strong case made out and the circumstances require it. I'll go shortly into an experience that I had earlier this year. I think I've mentioned that the courts will not ordinarily make novel orders. I had a matter earlier this year where effectively it was a very profitable business but it couldn't move forward because the partnership that underlay the business broke down. There were three different groups, and what we tried to achieve was effectively go to the court to ask the court to appoint a selling agent to break up and sell off the different parts of the business. And the court had great issues with whether or not the court could do that, assuming that it could find oppression, the oppression had been made out, whether the court could do it or would do it under the 233 remedies, and effectively said, no, unless you can work this out yourselves, we won't make those types of orders. Esmond and Nugget Time is one authority that I've found where the court has been prepared to engage in unusual types of orders, although that said, it's unusual in the circumstances that it was an unwinding order. So what occurred in this case was that the assets had been sold to a new company, which the minority shareholders had no interest in. Secured loans that had been provided by the majority shareholders that had been paid out by through the transaction, so they'd released money to pay them out. The minority shareholders were not paid out under those circumstances. The court agreed that this was a breach of 232, and then as a part of making orders under 2331J, unwound that entire transaction, required that the assets be sold back from the new company back to the old company for no value, and then effectively went about crafting orders that cured the mischief that was caused by the contravening transaction, and then wound up the original company. So effectively the court did lead to the winding up order, but crafted a series of orders to unwind the transaction that led to the oppression or had created the oppression. So, of course, courts won't make orders under 233 that require oversight, ongoing supervision in future management, effectively in the same way that they won't do that in the main for injunctions and injunctive relief. Courts will, however, in my experience, I think it's similar, I've spoken to my colleagues here, similar in their experiences, invariably when you walk into the court running an oppression action, the court will look at you and say, well, we'll have a go first at seeing if we can have a buyout by one of the shareholders, and if we can't, we'll move to a winding up. And usually the court will do that pretty quickly to encourage dialogue and encourage the parties to reach a settlement. And I find that often happens, that the court will say, well, my prospects here are limited, either there's going to be a buyout or we will wind it up, and require that be said in front of the parties so they understand what the ultimate logical consequences of bringing or the dispute that they're engaged in. That's it from me.
Thank you, Simon.